You all must be familiar with the term capitalist economy. In this, even though businesses are owned by individuals, it has limited government intervention. So for this, states come up with various regulatory framework that would regulate different aspects of market. And Competition Act is one such framework that is created for the regulation of competition in India's economic market. You all must have also heard about the term blockchain technology. But do you think this competition law will be enough to tackle all the issues which would arise due to use of blockchain? So now let's try to understand it. To begin, let me introduce you to the blockchain technology. It simply means chain of blocks in which data about various transactions is recorded. It's nearly impossible to hack this system because it's distributed throughout the network, and thus if one wants to manipulate the data stored on majority of the nodes would be required to be changed. It's also decentralized. That means process of adding a block to chain is not in the hands of any single entity that could act for its own benefit. Now let's try to understand what role does the Competition Act plays and whether this technology creates any challenges for this law. Basically, the objective of this act is to ensure freedom of trade, protect the interest of consumers, promote and sustain competition, prevent practices affecting competition adversely. And to fulfill all these, it makes an effort to prohibit anti-competitive practices. So now let's analyze blockchain technology in the view of provisions of Competition Act. Section 3 of the Act prohibits anti-competitive agreements which are of two types, horizontal and vertical. Horizontal is the one which is amongst competitors engaged in similar trade. So such kind of anti-competitive practices often takes form of cartelization. Most of the times, formation of a stable cartel is not possible due to market uncertainty and market volatility about prices. But here, blockchain technology, due to its transparency in the information stored on it, could reduce this uncertainty. The data exchanged through blockchain also includes competition-sensitive information, due to which enterprises would get to know about real-time information about market conditions. All such factors would make it easy for the enterprises to form cartels. Not only this, but one of the applications of blockchain, that is smart contracts, which make automated execution of agreement possible, could be used to self-enforce collusion by misusing it to self-execute punishment on a co-conspirator who deviates from the collusive agreement. The next type we have is vertical agreement. So here, if for an entity, access to use a blockchain application is denied, it could take form of refuse to deal agreement. Or if blockchain platform and developer of blockchain applications enter into an agreement for prohibiting developer from dealing with any other competing platform, then it would be exclusive distribution agreement. Now these possibilities would be in contravention of the Competition Act. So for that, now I would like to put forth some regulatory measures. We must understand that for any anti-competitive agreement to be successful, it is necessary that the firms that are part of such agreement are able to interact and arrive at mutually agreeable coordination strategy, monitor each other's conduct, and punish a firm in case of deviation from the agreement. And unfortunately, all these conditions can be met with the help of blockchain technology due to its various features. Thus, it is very important to utilize all these features of blockchain carefully. So the very first solution can be to restrict the data that is being shared to only relevant and non-sensitive data. Even in the case of Builders Association of India versus Cement Association of India, it was held that the availability of commercially sensitive information to all the competitors could result in anti-competitive outcomes. Its example can be Corda blockchain, where if a transaction takes place, only the minimal and required information is recorded. This would keep transparency as well as uncertainty of market intact. And along with restricting the kind of information to be shared, we can also restrict the access to the information. That means by restricting access in case of permissioned blockchain and encrypting data in case of permissionless public blockchain, we can create opacity effect for those who do not need to have access to any particular information. Lastly, in case of vertical agreements, measures should be taken for governing the rules of permissioned blockchains, because it is more likely that in the case of permissioned blockchains, vertical anti-competitive agreements could be formed, as here access to the blockchain can be restricted and controlled. Now, if we move further, Section 4 of the Act prohibits a dominant enterprise from abusing its position. But Competition Act would be beneficial only when it is applied to appropriate market. For this, before determining market power, first the study on relevancy of market shall be done. So now let's understand in a brief how relevant markets can be defined in field of blockchain technology. Firstly, relevant product market means wherein all the products and services which are regarded as interchangeable by the consumer are included. So each blockchain application which is in itself a distinct ledger or blockchains with similar applications could be considered as relevant product market. On the other hand, it's very difficult to define relevant geographic market due to pseudonymous and indefinite nature of blockchain. So it may be defined as per the facts of the case. Now once the relevant market is defined, we can analyze the market power based on factors such as number of users, number of recorded transactions and blocks, revenue and so on. So let's move further and understand what can be possible situations of abuse of dominance in blockchain technology and what are the required regulatory measures for the same. Entities already having an existing dominant position may refuse to provide access to a blockchain application to other small enterprises in the market. But before punishing such conduct, refusal for an access must be examined, and only if it is without any valid reasons, further punitive measures shall be taken. Because sometimes it may be that the entities do not have required cybersecurity measures. But sometimes it may actually be anti-competitive if the blockchain for which access is denied is an essential facility. For instance, if a blockchain application is developed for recording all the medical details of people, and if any new life insurance company is denied access to it, then it would not be able to compete effectively. Here, it's impossible to create similar database as it is historical. Thus, this becomes an essential facility, and hence in such cases, measures should be taken so that new entrant is provided with access to such blockchain application on fair and reasonable terms without any discrimination. Further, there can also be indirect restriction to access, as few companies may provide opportunity for an access but keep a higher cost of membership. In such cases, it must be analyzed whether the cost of membership is naturally appropriate or is a strategic plan to keep out the competitors, and accordingly further regulatory actions must be taken. Lastly, we must also give attention to what Organization for Economic Cooperation and Development has recognized. It is of the view that there is need for coordination among blockchain members to adopt common technical standards to ensure increasing competition. But while setting up technical standards, a dominant firm may include its patented technology as part of the standards, and afterwards it may refuse to provide its access, or else it may demand heavy royalties. Thus, it has to be ensured that all the enterprises, either dominant or small entities, must be able to participate in process of setting technical standards without any restriction. And we must ensure effective compliance with the standard on fair, reasonable, and non-discriminatory terms. Now lastly, I would like to conclude by putting forward the suggestions for stakeholders of CCI and blockchain technology for the purpose of development of the economy as a whole. Ambit of Section 3 and 4 must be widened so that there is no loophole for this new technology to escape from it. Regular sanity checks on operation mechanisms, agreements and smart contracts must be done. And adherence to all the competition law rules should be there while entering into any agreements or smart contracts through blockchain. Thank you.